5 seconds. Start. Heard learned senior counsel for the petitioner and the respondent numbers 1 to 3 and learned counsel for the respondent numbers 7 and 8. It is a classic case where instead of acting in a just, fair and equitable manner, the statutory corporation or state instrumentality has acted in a high-handed manner while exercising arbitrary powers with no sense of fairness in a matter of commercial interest. The Indian Oil Corporation Limited, after having lost before the single judge and the division bench of the High Court of Calcutta in successful defending its above action, has preferred this special leave petition probably in order to cover its illegal action. The special leave petition is directed against the judgment and order dated 4/7/2018 passed by the division bench of the High Court, upholding the mandamus issued by the single judge on 3/7/2012 in a writ petition directing the IOCL to maintain the supply of kerosene to the respondent number 1 till it is reconstituted or its dealership agreement is terminated. The partnership was to work as an agency distributor of kerosene oil for the IOCL. The said partnership firm entered into a kerosene dealership agreement with the IOCL on 11/5/1990, which inter alia specifically provided that in the event of death of any of the partners of the partnership firm, the dealer shall immediately inform the corporation and provide details of the heirs and legal representatives of the deceased partner. It further provided that IOCL shall have an option to continue with the dealership with the existing firm or to have fresh agreement of dealership with the reconstituted firm or to terminate the dealership agreement. The decision of the IOCL in this behalf shall be final and binding upon all parties. One of the partners of the aforesaid partnership firm having 55% shares in the firm died on 29/11/2009, leaving behind his wife, 7 sons and 4 daughters as his heirs and the legal representatives, which include the 2 sons who were already working as partners in the firm. Pending the above confusion regarding the reconstitution of the partnership firm, the IOCL approved the continuation of the firm till 14/6/2010 and advised them to furnish documents for the reconstitution of the firm. Accordingly, the subsisting partners on 13/4/2010 submitted a proposal for the reconstitution of the firm with the surviving partners and one another legal heir of the deceased with necessary documents and the reconstitution fee of rupees 25,000. Despite the above, the firm was informed that the validity of the token to supply kerosene would not be extended beyond 14/6/2010 if a fresh agreement is not executed. The representations of the partners to continue supplies were all in vain. Thus, the firm and its partners were compelled to invoke the writ jurisdiction of the High Court under Article 226 of the Constitution by filing writ petition number 758 of 20102. The firm and its subsisting partners therein prayed for declaring clause of the policy guidelines dated 1/12/2008 to be legal and contrary to the provisions of the Indian Partnership Act 1932 for a mandamus to renew the license to supply kerosene and to allow reconstitution of the partnership firm in term of the partnership deed dated 24/11/1989. A further prayer was made to extend the validity of the token for the supply of the kerosene and not to stop it after 14/6/2010 so that the partnership firm may continue its business till the reconstitution of the firm. The aforesaid writ petition was allowed wide judgment and order dated 3/7/2012 directing the IOCL to allow the partnership firm to be reconstituted subject to any order that may be passed in the probate case or by the competent civil court in the event any of the legal heirs approaches the court. The aggrieved heirs were given liberty to get their rights by decided by the competent civil court. The court directed that till their rights are not decided, the partnership firm will be allowed to continue with its subsisting partners and to receive supplies of kerosene. The counsel for the respondents 1, 2 and 3, that is the partnership firm and the surviving partners, submitted that under the deed of partnership dated 24/11/1989 it has been specifically stipulated wide clause 18 that in the event of death of any of the partner, the partnership will not cease to function, rather it shall continue to carry on the business, and the surviving partners may admit any of the competent heirs of the deceased partner to the partnership so as to reconstitute it. The dealership agreement dated 11/5/1990 also does not provide for a cessation of the existing partnership on the death of one of the partners. Rather, it provides to continue the dealers with the existing firm or to have a fresh dealership agreement with the firm if reconstituted or to terminate the dealership agreement. Accordingly, in view of the aforesaid facts and circumstances, we do not propose to entertain the special leave petition and to interfere with the impugned order of the High Court. Full stop.